mentioned in my court of case, my last two courts I mentioned, London Senior Advocate Mr. M.K. Lag has denied consent. Your Lordship has passed an order that on the next day, no adjournment will be given to them.
On the next day when the case is taken up.
To them, if your Lordship may take it before writing, they said, on 8th, what is the situation in the trial court? The trial court will pass final order. I have won the title suit, my lord, and 2197, my this order is subject to that and the 104. Very limited.
See, unless there is consent, we can't take up matters out of turn. But whenever the case is taken up, we will not grant them adjournment under any circumstances. We have already passed a judicial order that we will not grant them adjournment. But you ensure that you are not.
I am today also.
We can't be so. We don't have so much of speed that we will take up the matter. But if the
16.
case
Mr. Lai person, he is in Delhi now.
we don't bother about it,
Yes,
madam.
yes, madam.
Your counsel in 100% of the cases, not less than 5 adjournments for each hearing. Correct? So whenever he is available, he should have given consent.
Yes.
But he refused to give consent, which we have recorded. Right? On the next day, he will not give you consent. And if you seek adjournment, we will put very heavy cost to be paid to the applicant. Not less than rupees 1 lakh. Not less than rupees 1 lakh.
So one thing is from the list at item number 28, so hearing is first appeal. I was saying it will be taken up because the executing court is taking course.
Sorry?
First appeal at serial number 28. So
We do not know. Call the other side. They took up the other side. Then only the matter can be done.
taken that, I informed them, my lord, they were already.
We do not know. We just do not know. Let us do something. What is it? Which is of which year?
First appeal of 2023. Hearing is.
That's right. It will come in its own time.
From supplementary list for orders, item 1, first appeal 367 of 2018, along with item 2 to 399.
As per the office note. Notices were issued in first appeal number 367 of 2018 to the private respondents. Some of them have been personally served and some of them have been served through their family members. And the notice upon rest of the respondents, then the service report with regard to notice upon rest of the respondents have not been received. So far as ordinary process, service through ordinary process is concerned. The notices which have been personally served and the notices which have been served through family members are accepted as validly served. Office is directed to send express reminder to the concerned court for sending service report in connection with the remaining respondents. The express reminder should be sent within a period of 1 week from today. Even if the period granted by this court expires during the summer vacation. Post this case on 13th of June.
Waiting service.
Just a minute. The service report with regard to remaining respondents, we sent to this court latest by 6th of June. Post on 13th of June. Office is directed to also prepare appropriate office notes in connection with those who have entered appearance by filing वकालत. And next day जो नहीं सर्व हो पाएंगे, I pass an order for substituted service officers. नेक्स्ट डे यही ऑर्डर होने वाला है. आप अपना बस पिटिशन तैयार रखें. नेक्स्ट डे 13th को है, उसके जस्ट नेक्स्ट डे हम लोग रख देंगे फॉर सब्स्टिट्यूटेड सर्विस ऑफिसर्स. 20 तारीख को रखेंगे. आप अपना एफिडेविट तैयार करें. And then once the substituted service of notice is complete, we will proceed for filing. और दूसरी चीज ये बोल रहे थे, एक सेकेंड. Office is also directed to prepare a note, a chart showing as to which of the appeal, as to the award against which each appeal has been filed by the private respondents. वो chart रहने से easy हो जाएगा.
उससे कनेक्ट करने में
हाँ, कनेक्ट करने में सुविधा हो जाएगी. और कुछ अगर मर गया होंगे तो उनका क्या करेंगे?
वो हम वेरीफाई करवा लेते हैं. अगर नोटिस में तो रिपोर्ट में
वो तो आएगा रिपोर्ट में, लेकिन अगर मान
फिर सब्स्टिट्यूशन तो फाइल करना ही पड़ेगा.
तो उससे आपको टैली करना पड़ेगा कोरस्पॉन्डिंग रिकॉर्ड से, क्योंकि उनका भी फर्स्ट अपील फाइल हुआ होगा.
करवा लेंगे. वो हम करवा लेंगे.
क्योंकि बहुत सारे लोगों ने फाइल किया होगा.
मैं अभी नोटिस जितना आया हुआ उसमें तो कहीं पर कुछ
अभी तक तो कुछ नहीं है. अभी तक कुछ डेट का कोई रिपोर्ट नहीं है.
नहीं, अगर वो एक दो होगा तो उसको हम लोग मैच करके करवा लेंगे.
From supplementary is for admission item 400, contempt civil 274 of 2024.
The joining has been accepted. We are filing on compliance report also, right? So far as payment,
Joining has been completed, so far the payment is
payment.
concerned.
Yes, we are carrying the check, one supplementary affidavit. We are making minutes, we have made in this affidavit. That it may be. Yes.
नहीं.
We are carrying the check, but we have made only a small prayer. That this will be disbursed after the adjudication of the, that is a prayer. And we are carrying the check also.
hand it over.
Yes, we are receiving.
Will be viewed.
We have given the computation chart notes. If they are having any problem with that, 72 lakh was emerging out, 10% towards NPS that has been deducted. Yes, we have given the entire details of that.
That's
In the
your
affidavit-
entire details is here.
Yes, yes. If they do have any, they may represent before the authority or may keep it to them.
For representation, what representation?
The computation that we have given,
Computation dispute में हम लोग नहीं जाने वाले. वो आप अपना you just take care of yourself. We are not going to enter into any kind of computation.
details we have given, we have said 72 lakh payable and instruction that NPS 10% of total
The
body.
direction which
6% interest has also been given. Delayed. Detailed computation is there.
Whatever be it, we will not enter into that.
So we will receive melody. It may be kept on record.
नाम हम check करें.
हाँ. ये वो सब alert हो गए.
Amount बताइए, photocopy.
It is yes, ma'am. If I just forward this photo,
I'll give you back.
yes.
और I'll keep it.
It might
आप
not
receive
be-
ले
I will just take the
just receive, उनको receive करें.
ये receipt.
कर दिए?
नहीं.
Good. You are advocate on record.
Yes. Well, we will find from this the meantime that Joining has been given on page number 5. And then when page number 6, 7, the detailed computation has been done. So because there was a order also for 6% interest for delay. So that has been also computed. And we have also given that increment part also. Yes, we have not kept the salary phase as per the increment that is.
How will you secure this amount? Yes? How will you secure this amount?
Action with that regard, because there is an action that is subject to the outcome of the LPA.
It will be subject to the outcome of the calculation. But how will you secure this amount? Suppose you lose and you utilize this money. How will you secure this? Seek instructions. You have landed property.
I have to see.
You have to give some kind of security. That has to be there. You have to secure their interest also. And as it is, you are making, now the stay is rejected. Just find it out. Or we'll just simply say it is subject to the result of it. That is what we can say because the stay is rejected.
Yes, that's absolutely there. And I leave it to my lord because as an institutional value, because government exchequer is involved, so we have to come on affidavits, everything.
That's
So we leave it to my lord because and in
we'll say that it is subject to the result of it. Content schedule 274 of 2024. The learned counsel for the parties at present. A supplementary show cause has been filed on behalf of opposite party number 2 by the affidavit dated 6/7/2025 during the court proceedings which is taken on record. The learned counsel for the opposite party has submitted that during the court proceedings, the learned counsel for the opposite party has handed over a check. Is this pay order or check?
check it.
A check
Check.
amounting to rupees 60,16,060 dated 6/5/2025 of HDFC Bank in favor of the petitioner, which according to the opposite party amounts to 50% of the back wages and also interest at the rate of 6% per annum from the date of pronouncement of judgment till payment. He has submitted that a calculation sheet has also been annexed along with the supplementary show cause. The learned counsel has submitted that since LPA number 160 of 2024 is pending, it may be observed that the payment is subject to the final result of the LPA.
I submit that some security, that is my affidavit. Might not be observed. My submission would
The
be
learned counsel has submitted that. क्योंकि इस तरह की चीज़ों को रिजेक्ट करने से कोई फायदा नहीं है. Content is pending.
yes.
Content हम ड्रॉप नहीं करेंगे. And I'll take care of it. How does this money come back? आप एकदम चिंता. एक आध केस में कर चुके हैं.
I leave it to my
I know how to get the money
Yes,
back.
yes, ma'am.
If I know how to make payment, I know how to get it back. इसलिए कुछ चिंता का बात नहीं. बताइए कब रखें?
Now we have moved on application for early hearing.
The learned
But
counsel
Honorable
has
Dean-
also submitted that a petition for early hearing has been moved before the Honorable Division Bench. You will cooperate in early hearing? The learned counsel for the petitioner has submitted that he shall cooperate with early hearing of the. ये तो हो गया आपका consent. चलिए.
When
the learned counsel for the petitioner has given his receiving on photocopy of the check and undertakes to hand over the check to the petitioner. बताइए क्या करते हैं? Just
well, the real difficulty that is being expressed by DB1 is that positive of judges. So September, October, November is the normal process of hearing that is being given. So that we try to impress upon the honorable court that our nature is that. But that is what is emerging out. So my petition is pending, madam.
You can refer to this order.
Yes,
Say that
now I
payment
will
has
take
been
a
made.
formality.
The petition has
July
also
के
been given
अगस्त-
joining. इनका schedule date of retirement कब है?
इनका भी है 7-8 साल से।
सात आठ साल सर्विस है, वसूली करने में आपको दिक्कत नहीं होगी, बाकी पीएफ वगैरह बहुत कुछ होगा इनका, आई एम श्योर. योर अमाउंट इज वेल सिक्योर्ड.
Whether she will continue or not, that is one.
इतना लड़के
May her husband is working in IIT Ghaziabad, so probably he has also missed the. So they may that is.
We do not know, that is their.
That is because my Lord has expressed that is.
Holds this case on 11th of July.
It can come in first week of August.
Okay.
Because opening week of
8th of August.
Grateful.
Awaiting the judgment of 8th August or after disposal of the LPA, whichever is earlier.
My.
For hearing item 401, first appeal 140 of 2016.
Two judgments that I would not if I may kindly request. This is 2014. Again, the onus is upon the 10, para 9 and 10 is in. And there is one judgment of 2023. My Lord's judgment, which has relied upon this judgment of 2018 that the award cannot be a deciding factor for awarding any enhancement to the compensation that has already been given. Sale deed has to be brought on record for that particular year, for that particular year. Here, not a single sale deed has been exhibited by them, only the awards they have relied upon, and that too the judgment for the land that has been acquired 13 kilometers away in the year 1965. And that Bajra Colliery was acquired prior to the rationalization, and thereafter those developments took place. And this was after the acquisition in 1975, the development took place. So they cannot be kept in parallels.
What is the consent all about? Was there any consent? In your grounds of appeal, you have mentioned that there was some kind of consent or compromise.
My Lord, because there is no document in that, I was not saying that. Though in the ground we have taken that there was a compromise between the parties, and on that compromise the award was prepared. I was searching for a document, I could not find any.
That's very good. You have referred to certain exhibits also
Yes,
in the ground.
yes.
What is the name of the claimant? Name of the claimant.
Sitaram Sahu and Satyanarayan Sahu. Sitaram Sahu.
They are the original awardees. Who are the original
Lordship,
awardees?
we have the power of attorney holders on behalf of the original awardees. Lordship. Original awardees are Lordship Basu Sahu, Ramkishore Sahu, and Ramkishore Sahu.
Who gave you the power of attorney?
Power of attorney was given by Basu Sahu and Kanchan Sahu.
They are allied,
Yes, sir.
but they are not the applicants before this court.
Appellants are CCL. Lordship, we are representing the respondents who are the claimants.
They are representing the claimants after the death of the claimant.
No, no, Lordship. There was a power of attorney executed in our
You
favor.
mentioned
It has been mentioned, Lordship.
So this copy. This is the
Reference case application. Your Lordship had been pleased to ask why we had moved a reference case in 2001, Lordship. Prior to that, there was one more reference case in the same award, Lordship. That was regarding opposite party number 3, 4, 5 and 6 had filed an objection along with our objection also. We have got a copy of our objections as well. In that they had mentioned that since they are also entitled to compensation, hence the award may not be released in our favor. And after deciding the reference case 998, it was again the judge had made a sent a letter to the CCL manager for release of the amount. In 2001, the amount was released, and within 4 weeks, we had filed for the reference case. So it was well within the time.
So there was a dispute interest.
Yes, sir. And that was resolved in reference case 9 of 98.
There is that order. It's not in the record.
Lordship, it will be on record, Lordship. I have a copy of the order, Lordship. Lordship, this is the written statement that we have filed. In this, we have specifically mentioned about the power of attorney execution.
It is required to be apportioned amongst 3 sons.
Yes, sir, Lordship. The present claimants, it has already been decided in that judgment, Lordship. Since the other opposite parties could not produce any document with regard to their title, hence the learned judge had passed the award in our favor, Lordship.
This Basu Sahu and Kanchan Sahu
Yes, sir, Lordship.
are allied.
Yes, sir, Lordship. They are alive, Lordship.
What is the date of power of attorney?
Power of attorney dated 1693. Power of attorney number 255 dated 1693.
Who is Laldev Sahu?
Biswendra Sahu had two sons, Laldev Sahu and Ramchandra Sahu. Biswendra Sahu died, and thereafter the land came in possession of Laldev Sahu and Ramchandra Sahu, who also died, leaving behind their sons heirs. This is from the reference case number 9 of 98. These facts are not there in our case.
Who is the original awardee? Please give me the name. This is award number. Award number. This is reference case number 13 of 2001. Where is the award? Original award. What is the date of the award? And in whose name it was prepared?
You are on the reference case number 9 of 98.
I'm just talking about my
The current.
This is reference case number 13 of 2001. In which Sitaram Sahu, son of Basu Sahu, and Satyanarayan Prasad Gupta, son of Kanchan Prasad, are the respondents. So award must have been prepared in their name. So I just wanted to know what is the date of the award and what is the award number.
This should be total amount that has to be paid. That order was passed on 10/12/2015.
We will come to that later. First, the genesis. LR case number 13 of 2001 is under section 17(2) of CE Act.
This was decided on 30th November 2015. And
That's
they-
right, but I just want to know who is the original awardee. Are they the Sitaram Sahu and Satyanarayan Sah Prasad are the original awardees? No. In the name of Vishun Dayal Sahu. Award as per your petition.
Yes, Your Lordship.
Even in the judgment, my lord, it has been mentioned originally award was prepared in the name of Vishnu Dayal Sahu in the first paragraph itself.
He happens to be my grandfather. Father of Sri Basu Sahu.
He had two sons, Basu Sahu and
And Kanchan Sahu.
two sons.
Yes, Your Lordship.
Vishnu Dayal Sahu, from that reference case, my lord, it appears that he had two sons, Laldev Sahu and Ramchandra Sahu.
In their petition, they have mentioned that the land, how much is the land worth?
6.1. Total 12 point something, 12 acres, yes, 12 acres were required, out of which they say that their share was 6.01 acres.
6.01?
Yes, Lordship. 6.0.
What about the remaining?
Your Lordship, for 6.1 acres we received the amount way back in the year 2001, and for the remaining it was disbursed in the year 2015. Lordship.
For the remaining? Why only 6.1 acres was given when the land of 12.02 acres were acquired?
So my concern was only with regard to 6.01 acres.
Right.
Lordship. It was partitioned.
Leadership, they have given a written notes. They have given a written notes to me. Is that this we can be reduced? Yes, I have no. I do not have a copy. I just given that one because he was referring to that document.
हमने कोई 5 acres ऐसा तो कुछ उनको दिखा नहीं। उनके तो इससे बता नहीं हुआ। All of it. here, Rana? I just slowly take it down. The present appeal arises out of reference case number 13 of 2001. The matter arises out of acquisition of land by Appellant CCL. Total area 12.02 acres. The notification under section 4 of Land Acquisition Act was issued on, give me the date,
29/12/76.
on 29/12/1976. As per the petition filed by Sitaram Sahu, son of Basu Sahu, and Satyanarayan Prasad Gupta, son of Shri Kanchan Prasad Sahu, before the learned court, under section 17 within bracket 2 of coal bearing, what is the name of that? Coal bearing
Acquisition with coal
coal bearing areas within bracket acquisition and development bracket rules Act 1957. The two claimants have stated that the land area, acquired land of 12.02 acres was acquired jointly in the name of Ramchandra Sahu and Laldev Sahu. And they were the descendants of late Laldev Sahu. And consequently, they were concerned only with 6.01 acres of land, which was half share of the total acquired land. It was their case that the appellant, that is CCL, had fixed the compensation at rupees 21,431 for the land to the extent of 6.01 acres, which was paid to them by two checks dated 30/4/2001 and 23/3/2001. And thereafter, within a short time, they filed the petition under section 17 with bracket 2 of the aforesaid Act on 30/5/2001. It was their case that the CCL has offered very low compensation and was not in accordance with the market rate of the property, and that the market value should have been rupees 15 lakhs, as the property is situated in industrial belt such as North Kernpura coalfields. It was also their case that similar acquisition has been done in the vicinity for Toang Colliery, Bachra Colliery and Pilparwar project, wherein the courts have fixed compensation at the rate of rupees 90,000 to rupees 1 lakh per acre. It was their further case that in terms of the circular dated 12/5/1989, the claimants were also entitled to receive solatium and higher rate of interest. The Petition was filed seeking enhancement of compensation and also for payment of solution at the rate of 13% and higher rate of interest at the rate of 15% from the date of acquisition. This is their case, correct? At this, the learned counsel for the respondents had submitted that they had filed a cross objection to the present appeal, which was numbered as CU number 5 of 2016, which has been dismissed for non-compliance of preemptory order dated 20/4/2018, as the defects pointed out by the office was not cured. However, the fact remains that till date, the application for restoration has not been filed. To this, the counsel for the respondents has submitted that they are taking steps to do the needful in the process, with respect to the cross objection.
But we would like to raise a contentions of cross objection over here, not just directly. We have a judgment to suppose that filing of cross objection is not mandatory. It may be raised by any authority also during the course of the appeal.
Adnan?
I did not bring, but it has been considered. And really, there is a judgment which says that prior to the notification, it was not
You
retrospective.
see, I'll tell you one thing, Mr.
This
Counsel.
is
Now your cross objection has been rejected. So you have to take steps in the cross objection. Once your cross objection has been rejected, it is difficult for us to give any pronouncement in this issue.
But it is not mandatory for filing of cross objection. Judgment, there are numerous judgments that says that it is not mandatory and mere oral plea during the course of appeal may also have the cross objected to raise that plea.
Well, there should be a judgment edition that if filed and dismissed, then whether the same can be taken in
That
the
should
first
be,
appeal.
but that is not the case, Lordship. I'm
It
just
has been dismissed.
dismissed for default, Lordship. Lordship, on 11/9/24, when we tried to get a printout of the case status, that case was still pending.
We do not know. We are not concerned about what you are doing in the cross.
Children, we may be allowed to raise a plea of objection over here, Lordship.
The learned counsel for the respondents has submitted that the cross objection having been dismissed for non-removal of defect, still it is open to the respondents to raise the plea in the present proceedings with regard to payment of solatium and interest, irrespective of any cross objection having been filed. The learned counsel has submitted that the cross objection, that the amount of solatium and interest, that the respondents are entitled to amount of solatium and interest to the extent of 30% and 15% respectively from the date of acquisition.
Yes, Lordship.
Is it from the date of acquisition?
From the date of collector's award, Lordship.
From the date of the award, not from the date of acquisition.
फर्स्ट अवार्ड बनेगा, अवार्ड के बाद जब 18 का पिटीशन जो फाइल होता है तो उसके बाद ये होता है कि आप जो भी आएगा सोलेशियम एंड 1 साल के अंदर पेड अमाउंट अगर पेड हो जाता है विद इन टाइम तो कोई बात नहीं है, उसके बाद नहीं अगर पेड होता तो 15% इंटरेस्ट टिल द पेमेंट ऑफ द अवार्डेड
solatium and interest from the date of the award, and to this the learned counsel for the appellant has raised serious objection and has submitted that once the cross objection has been dismissed for default, it is and the opposite party have themselves submitted that they are taking steps for restoration of the cross objection. Therefore, such issue may not be decided in this present appeal. If the cross objection is ultimately restored to its original file, then certainly appropriate order can be passed in the cross objection.
Actually, all the legal recourses are not available. They are taking the same plea.
She has submitted that the legal recourse to claim compensate solatium and interest as claimed by the as argued by the respondents is still available. We'll see that what is to be done. Yeah, please
Yes,
next.
Lordship, for cross objection.
Which paragraph?
Para 22 and 23, Lordship. Very Lordship. In our view, the opinion expressed by so and so High Court on behalf of Division Bench in so and so case in view expressed by so and so. We hold that the respondent defendant in an appeal can, without filing cross objections, attack an adverse finding upon which a decree in a part has been passed against the respondent for purpose of sustaining the decree to the extent the lower court has dismissed the suit against the defendant respondent. Filing of cross objection after the 1976 amendment is purely optional and not mandatory. In para
उन्हीं के submission में लिखा है. He has relied upon the judgment passed by the Honorable Supreme Court, reported in AIR 1999 SC 3571. Within that case, Ravindra Kumar Sharma versus State of Assam and others. Paragraph 22 and 23. To submit that it has been held by the Honorable Supreme Court that respondent defendant in an appeal can, without filing any cross objection, attack an adverse finding upon which a decree in part has been passed against the respondent, and for the purposes of sustaining the decree to the extent the lower court has dismissed the suit against the defendant's respondents, it has been held that the filing of cross objection after 1976 amendment in CPC is purely optional and not mandatory. The learned counsel for the आपका तो submission लिखा था.
That is res judicata in this case. They have already raised a plea.
The learned
Para
counsel,
23
just
also
a
uses
moment.
that.
Para?
Para 23, Lordship.
Wait. Para 22 and 23 both. 23 says what?
The respondents before us therefore entitled to contend that the finding of High Court in regard of absence of reasonable and probable cause or malice upon which the decree of pecuniary damages and B and C schedules was based can be attacked by the respondents for the purpose of sustaining the decree of the High Court refusing to pass decree of non-pecuniary damages as per A schedule.
What are you reading?
Para 23.
23 में क्या है? There is no res judicata.
The filing of cross objection against adverse finding is not obligatory. There is no res
That's right, we have seen
judicata.
that.
There is no res judicata, Lordship.
But once you file and it is rejected, then there is no res judicata.
Yes, sir. It has been dismissed for default, Lordship. We still have an open gate to file it afresh. If our case has been dismissed for default, the party aggrieved always has an option to file it afresh, Lordship.
ऐसा कौन सा सर कहाँ से?
Recent judgment है, Lordship.
सुप्रीम कोर्ट में सूट के लिए आया है. सूट के लिए आया है सूट के लिए.
Yes, Lordship.
अपील के लिए भी आया है।
नहीं, I am talking about.
ऐसा रीसेंट जजमेंट की बात मत किया कीजिए, समझे ना? दिन रात फोन मेरे हाथ में ही रहता है रीसेंट जजमेंट का कहानी सुनने। It is only for the suit. But once your appeal is rejected, once your cross objection stands rejected, what is the consequence?
Your Lordship, if my grievance will be answered over here, then I will not be availing that restoration of.
Free style नहीं चलता है इस केस में। CPC doesn't work in this manner. और 2018 से DFD करती है, थोड़ा तो शर्म करिए आप।
Lordship, 24 तक Lordship वो DFD नहीं हुआ था Lordship. हमारे पास स्टेटस रिपोर्ट है Lordship. इसलिए हमने IA भी डाला था, IA भी एक्सेप्ट हुआ था.
आपको नहीं पता है कि आपका प्री-एंट्री ऑर्डर है तो DFD हुआ था?
Lordship, कोई ऑर्डर भी उस टाइम तक अपलोडेड नहीं।
सारा दोष हाई कोर्ट पे मत दीजिए और अपनी नेग्लिजेंस को जस्टिफाई करते रहिए and let the litigant suffer and go to hell. This is what you want to say.
We are the new
You have no responsibility. हाई कोर्ट का वेबसाइट में अपलोड नहीं हुआ, अपडेट नहीं हुआ, तो you will say it was not dismissed for default.
Lordship, that is not what I am submitting.
First thing is that you have done a disservice to your client. First, acknowledge it.
My sincere apologies, Lordship, but
That
we
is
were
the
not
first
the,
acknowledgement.
we were not the original counsel, Lordship. We have obtained this from by way of NOC.
So you should have taken the NOC. When you can't defend your earlier counsel, don't take the NOC. When you take the NOC, you have to defend your litigant also, and you have to defend your counsel also. जिससे आप NOC लिए हैं। दूसरे के ऊपर दोष लगाने से solution नहीं होता।
Lordship, regarding removal of defect, we have filed IA because we wanted to remove the defect.
करते नहीं जाते थे। At this, the learned counsel for the appellant has submitted that maybe that the filing of cross objection is optional and not mandatory. But once it is filed and is dismissed for default, then under such circumstances, the relief as was prayed for through cross objection cannot be granted in this proceeding. And for that purpose, the respondents ought to have taken appropriate steps for restoration of cross objection. That's it? You are done? आगे का कहानी सुनिए। Which all witnesses were examined?
Two witnesses have been examined from their side and two witnesses. They are the claimants themselves in this reference case. They have been examined.
One is Sitaram Sahu.
And other one is Satyendra Narayan Prasad.
Okay, these two persons have been examined. Sitaram Sahu is 49 years and in the year 2001. And Satyanarayan is 35 years in the year 2000. Sorry, 2005. 2005 में 49 and 35 years. Were they born in 76? Were you born in 76? Sure.
आधार कार्ड है एक बार तुरंत मिल जाएगा।
30 years का होगा 2006.
बच्चे रहे होंगे।
In fact,
Anyways, let us see the evidence of PW or this claimant number 1, applicant number 1.
Sitaram Sahu was born in 55 and Satyanarayan Sahu was born in 66.
1955 and Satyanarayan in
1966.
1966. 76 का acquisition कोश में रहे होंगे।
then that age is
It's okay, we'll take it. You just read it. You
Paris
have?
7.
You
Paris
have? पढ़िए सर। जहाँ मार्क करने बोलेंगे पेंसिल से। वो तो फिर रीड करो, क्रॉस के साथ पढ़ेंगे। किसको हिंदी पढ़ी आती है? पढ़ी आपको आती है? CBSE से पढ़े हैं? कोई बात नहीं, हिंदी तो पढ़ी
CCL ने मेरी जमीन 6.01 एकड़ अर्जित
सर आप पढ़िए ना प्लीज, आप बेहतर जानेंगे।
CCL ने मेरी जमीन 6.01 एकड़ अर्जित कोयला खनन हेतु की है। मुझे मुआवजा 21,431 रुपया मिला था। मार्केट रेट से मुआवजा नहीं दिया गया। मेरी जमीन विश्रामपुर ग्राम में थी। मैंने ग्राम के
बचरा कोलियरी
बचरा कोलियरी, करकट्टा कोलियरी,
वांग
तुआंग कोलियरी है। उसके
उस 695
नहीं 60-65 सालों से कार्यरत जो एरिया है जो मैं कोलियरी का 60-65 साल से कार्यरत है। विश्रामपुर शहर है। यहाँ स्कूल, कॉलेज, सीमेंट फैक्ट्री, अस्पताल एवं शॉपिंग सेंटर वगैरह है। मेरे जमीन की कीमत 3 लाख प्रति एकड़ या 36 लाख प्रति एकड़ है। इसी दर से वहाँ के आसपास की जमीन बिकती है। आय आसपास भी इसी रेट से जमीन बिकती है। विश्रामपुर की जमीन तथा बचरा दुकान की जमीन एक जैसी है। मैं मुआवजा लेते समय आपत्ति लिखकर मुआवजा नहीं लिया था, यानी बिना आपत्ति के साथ मुआवजा मिला था। मैं 36 लाख प्रति एकड़ की दर से जमीन बिक्री होने का कोई कागज दाखिल नहीं किया।
So he has stated that he has not raised any objection at the time of taking the compensation. Correct? This one? Cross. And then he is also saying कि present में इतना ये है।
किसी पे क्रॉस पे ही वो जवाब दिया है प्रति परीक्षा प्रति।
And then he is talking about the current rate of the land.
Yes, 36
He is talking about the current rate of the land, right? In the year 2001, not about the earlier date. That 76 में क्या rate था उसकी बात नहीं कर रहे, ठीक है? और next one.
नेक्स्ट है सत्यनारायण प्रसाद गुप्ता।
CCL
ने हम लोगों की 6 एकड़ जमीन ली है। उसके द्वारा दिया गया मुआवजा से हम लोग संतुष्ट नहीं हैं। हम लोग 1 लाख रुपया प्रति एकड़ ब्लैक वाटर में कहा जा रहा है। नेक्स्ट में आते हैं कोलियरी 1972 ईस्वी से चल रहा है। मेरी जमीन शहर तथा देहात दोनों जगहों में है। मेरी जमीन की अगल बगल में सेंट्रल स्कूल, खिलाड़ी सीमेंट फैक्ट्री रोड है। बचरा पीपरवार चूड़ी कोलियरी
बचरा पीपरवार चूड़ी कोलियरी आसपास में
बचरा 1972 से 1972 ईस्वी, पीपरवार 1990 ईस्वी के आसपास से चल रहा है। अधिकृत जमीन बचरा कोलियरी से सटा हुआ है। CCL ने बचरा पीपरवार में भी जमीन अधिकृत की है। पीपरवार तथा बचरा की जमीन से मेरी अधिग्रहित जमीन
कितना किलोमीटर बता रहे हैं? 13 किलोमीटर।
अच्छा प्रिया, जैसा गूगल में आज देखा जाता है, क्लाइंट ने भी बोला कि वो गलत वहाँ पर रिकॉर्ड वाइट इज एक्चुअली 6 किलोमीटर।
आप बोल सकते हैं, लिख नहीं पाए।
CCL फैक्ट्री में मेरी जमीन की दूरी
गूगल
CCL
का काम TRP बढ़ा
से
देंगे यहाँ
मेरी
पे।
जमीन की दूरी 5 किलोमीटर।
वी आर नॉट रेजिंग दैट।
हाँ, बेटर नॉट।
बचे
CCL फैक्ट्री से मेरी जमीन
जमीन 5 किलोमीटर पर होगी। बचड़ा परिवार वाली अधिकृत जमीन कर का मूल्यांकन किस
दर से हुआ
दर से हुआ है का कागज मैं दाखिल नहीं किया। हम लोग ऑब्जेक्शन के साथ मुआवजा प्राप्त किया। ये विटनेस है
क्लेमेंट नंबर 2।
क्लेमेंट नंबर 2 सत्यनारायण प्रसाद गुप्ता कर रहे हैं। हम लोग ऑब्जेक्शन के साथ मुआवजा प्राप्त किया।
डिस्टेंस के बारे में कोई क्लियर एविडेंस नहीं है।
क्लियर एविडेंस नहीं है। 5 किलोमीटर खाली आ रहा है।
नहीं, वो तो कोई
फैक्ट्री
फैक्ट्री से 5
सीमेंट
किलोमीटर।
फैक्ट्री से मेरी जमीन 5
बचरा से 5 किलोमीटर।
बचरा सीमेंट
CCL लिख रहे हैं इसमें, CCL सीमेंट फैक्ट्री से 5 किलोमीटर।
सीमेंट फैक्ट्री
ये
में सीमेंट फैक्ट्री से मेरी जमीन नॉट सीमेंट
अच्छा,
सीमेंट फैक्ट्री से मेरी जमीन
5 किलोमीटर।
5 किलोमीटर की दूरी पर होगी।
नहीं। क्रॉस में भी नहीं आया।
सीसीएल का क्रॉस ऑब्जेक्शन में आया है कि जितना सब सराउंडिंग है 5 to 6 किलोमीटर।
अजित कुमार सत्या विटनेस नंबर 1 निरीक्षक, ये भूमि विश्रामपुर ग्राम की है। ये CCL द्वारा दिनांक 21/4/76 जब दायर की दफा 4 की अधिसूचना निर्गत हुई थी। भूमि अर्जन के समय इस ग्राम की भूमि का सर्वेक्षण किया गया था ताकि ये जाना जा सके कि उस ग्राम की कौन सी प्लॉट किस्म की है। ये तदुपरांत भूमि का किस्म तथा दफा 4 की अधिसूचना के दिन विभिन्न किस्म की जमीन का बिक्री दर क्या था उसके लिए सेल फिगर प्राप्त किया गया था। ये कि दावेदार की भूमि किस्म दफा 4 के दिन की बिक्री दर को ध्यान में रखते हुए दावेदार को मुआवजा निर्धारित किया गया जो उचित एवं वैध है। यह कि दावेदार की जमीन जिस समय अधिग्रहण की गई थी उस समय सीसीएल अधिक दर पर सूद आदि भुगतान का प्रावधान नहीं था। यह दावेदार की भूमि और औद्योगिक क्षेत्र में नहीं पड़ती है। यह कि राय हिंदगिर बचरा कोलियरी अधिग्रहण भूमि से काफी दूर पर स्थित है तथा इन ग्रामों की भूमि की तुलना अधिग्रहित भूमि से नहीं की जा सकती है। ये सब विभिन्न प्रकार की है और ये सब कोलियरों अधिग्रहण के बाद स्थापित हुआ है। यह भूमि अधिग्रहण के दिन विश्रामपुर ग्राम बिल्कुल देहाती क्षेत्र था और यह विकास से यहाँ विकास की कोई किरण नहीं थी। यह कि शपथ पत्र स्वयं पढ़कर सच में सच किया। क्रॉस एग्जामिनेशन बचरा कोलियरी एनसीडीसी ने 1973 से पहले शुरू किया था। 1973 के बाद सीसीएल ने उस जगह में जमीन की। बचरा विश्रामपुर से 12 किलोमीटर इन माय क्रॉस एग्जामिनेशन दूरी पर है। विश्रामपुर होकर टंडवा रांची पिच रोड गांव के बगल से गुजरता है। डकरा चूरी केड़ी राय तुमान मानकी करकट्टा सभी नॉर्थ चंद्रपुरा कोलफील्ड के अंतर्गत हैं। ये सारे प्राइवेट कोलफील्ड्स था जो 1973 में राष्ट्रीयकृत हुआ है। विश्रामपुर में चारों तरफ दूर दूर तक कोलियरी है। 7-8 किलोमीटर दूरी पर है। विश्रामपुर का एक्विजिशंस संबंधित सेक्शन 9 का डिक्लेरेशन 1976 में हुआ था। अवार्ड बनाने में मेरी हिस्सेदारी नहीं थी। सोल डीड के आधार पर विश्रामपुर की जमीन का मूल्यांकन हुआ। किस सेल डीड के आधार पर किया गया था मुझे नहीं मालूम। सीसीएल के रिवाइज के रेवेन्यू डिपार्टमेंट द्वारा जमीन का मूल्यांकन किया गया है। 12/5/1989 को केंद्रीय सरकार ने एक सर्कुलर किया था। सीबी एक्ट के अधीन दिए जाने वाले जमीनों पर 30% सोलेशन एवं 15% इंटरेस्ट दिया जाए। केडी कोलियरी के लिए विश्रामपुर का जमीन लिया गया था। केडी हेसालोंग प्रोजेक्ट के अंदर में ही विश्रामपुर का जमीन पड़ता है। केडी कोलियरी शहर की सभी सुविधाएं हैं। ऐसी बात नहीं है कि केडी कोलियरी 1973 से पहले से चालू है। ऐसी बात नहीं है कि 1973 में केडी कोलियरी का नेशनलाइजेशन हुआ था। ऐसी बात नहीं है कि मुआवजा राशि कम है।
By getting to the evidence of witness number 1 on behalf of CCL, the learned counsel for the appellant has submitted that it is not in dispute that the acquired land falls under village Vishrampur and acquisition and notification under section 4 was issued on 21/4/1976. She has submitted that this witness has clearly stated that at the time of acquisition of land, the relevant survey was also done, and to find out as to the nature of the land, and different sales were also considered for fixation of compensation. And at that point of time, the interest, solatium, etc. were not paid. She has further submitted that the claim he has deposed that the land did not fall in industrial area and that the land is far away from Rai, Himgiri, Bajra, collieries. And the acquired land cannot be compared with the land of the aforesaid collieries. He has also stated in his brief that the nature of land is different, and in those collieries, in those lands, the collieries were established after the acquisition involved in the facilities.
And leadership was कि भूमि अधिग्रहण के दिन विश्रामपुर बिल्कुल देहाती क्षेत्र
He has
और विकास का
also
कोई किरण नहीं।
he has also deposed that at the time of acquisition, the land, the village Vishrampur was in absolute rural location, and there was no sign of any development.
So even the 20%
During
development
cross-examination.
cost that has to be deducted, that we developed thereafter.
During cross-examination, this witness has deposed that in that Bachra colliery was established in the year 1973.
Prior to
Prior-
1970.
Prior to 1973, and Vishrampur is 12 kilometers away from Bachra colliery, and there is a pitch road adjoining to the village Vishrampur, which goes to Ranchi. He has also deposed in cross-examination that Dakra, Churi, KD, K.D, Rai, Tuman, Manki, Karkatta, all these collieries fall under Chandrapura coalfields, and they were all private coalfields which were nationalized in the year 1973. He has further deposed during cross-examination that around Vishrampur colliery, there is colliery around Vishrampur, and which is around 7 to 8 kilometers away. And declaration under section 9 with respect to Vishrampur was made in the year 1976, and he had not participated at the time of preparation of the award. He has deposed that during that the valuation was done on the basis of sale deed, but could not disclose as to which sale deed were taken into consideration. He has further deposed that the Revenue Department of CCL undertakes the valuation of the property. He has further deposed that in the year 1989, a circular has been issued by the central government that for acquisition under Coal Bearing Act, 30% solution and 15% interest is payable. He has further deposed that Vishrampur, the land in Vishrampur was acquired for KD colliery, which and KD colliery falls under Hislam project. And in KD colliery, all urban facilities are available.
KD colliery also lies within Vishrampur.
Yes, ये तो बोल दिया ना, it was acquired for Vishrampur. He has also deposed that KD colliery, he has denied that the work in KD colliery commenced prior to 1973. He has also denied that KD colliery was nationalized in the year 1973. दूसरा कौन है?
दूसरे हैं ओम प्रकाश उरांव वंशश्री जोड़ा मैं
Yes.
ये भूमि विश्रामपुर ग्राम की है। ये CCL द्वारा दिनांक 21/4/75 जब दफा 4 की अधिसूचना निर्गत हुई थी, भूमि अर्जन के समय इस ग्राम की भूमि का सर्वेक्षण किया गया था ताकि ये जाना जा सके कि ग्राम की कौन प्लॉट किस किस्म की है। ये वही वर्गीकरण का प्रतिवेदन है जिस पर हल्का कर्मचारी श्री बोरो, राजस्व पदाधिकारी CCL श्री शारदा प्रसाद एवं अंचल अधिकारी गोलू का हस्ताक्षर है, जिसे मैं पहचानता हूँ। इससे प्रदर्श डैश अंकित किया जाए। यह कि तदुपरांत भूमि के किस्म तथा दफा 4 की अधिसूचना के दिन विभिन्न किस्म की जमीन पर बिक्री दर क्या थी उसके लिए सेल फिगर प्राप्त किया गया था। यह कि दावेदार की भूमि किस्म तथा दफा 4 के दिन की बिक्री दर का ध्यान में रखते हुए दावेदार का मुआवजा निर्धारित किया गया जो उचित एवं वैध था। यह कि दावेदार की जमीन जिस समय अधिग्रहित की गई थी उस समय CCL अधिक दर पर सूद आदि भुगतान का प्रावधान नहीं था। सोलेशियम अधिक दर पर सूद आदि भुगतान का प्रावधान नहीं था। यह कि दावेदार की भूमि औद्योगिक क्षेत्र में नहीं पड़ती है। यह कि राय हिंदगिरी बाचरा कोलियरी अधिग्रहण भूमि से काफी दूर पर स्थित है। इन ग्रामों की भूमि पर तुलना अधिग्रहित भूमि से नहीं की जा सकती है। ये सब विभिन्न प्रकार की है और ये सब कोलियरी भूमि अधिग्रहण के बाद स्थापित हुई है।
The learned counsel for the appellant has submitted that so far as the second witness on behalf of appellant CCL is concerned, he has also deposed in similar lines and he has clearly stated that notification under section 4 was issued on 21/4/1975. The notification under section 7 was issued on 27/1/1976 and notification under section 9 was issued on 29/12/1976 and these documents were marked exhibit as exhibit A, B and C respectively. Cross-examination.
The statement of land classification of land शारदा प्रसाद रेवेन्यू ऑफिसर CCL के हस्ताक्षर में है तथा कोलियरी के किस दर
The learned counsel has further submitted that this witness has exhibited a document which has been marked as exhibit B, which is the statement of land within bracket classification of land prepared by one Sharda Prasad, who was the revenue officer of CCL.
मैं हस्ताक्षर को पहचानते हैं। इसे प्रदर्श B अंकित किया जाए। इसे CCL मुर्मू के हस्ताक्षर CO मुर्मू के हस्ताक्षर को भी पहचानते हैं। CO के
What is another signature?
Yes.
Next.
Next.
Cross-examination.
कोलियरी एवं CO का नाम कोलियरी एवं
कर्मचारी एवं CO का नाम नहीं
कर्मचारी
बता
एवं CO का नाम नहीं बता सकते। हम मेरे सामने तैयार नहीं हुआ। 280 एकड़ जमीन कोयला उत्पादन के लिए लिया गया था। इस 780 एकड़ के नीचे एक ही किस्म का कोयला है जो डिस्प्ले करने के लिए लाया गया है। कोयला वाला जमीन तथा कहाँ और कोयला नहीं है। उसके कोयला वाला जमीन ही उच्च कोटि का है। बागीगण विश्रामपुर खिलाड़ी के 3 किस्म के हैं। कोयला देने के लिए विश्रामपुर के से खिलाड़ी जगह विश्रामपुर
बाकी इतना रेलेवेंट नहीं है.
वो फैक्ट्री है
हाँ.
जमीन है
The
कोयला है.
this witness during cross examination has stated that the statement was not prepared in his presence, and Khiladi is around 3 kilometers away from
30
Vishrampur.
3
3 kilometers. 3 kilometers away from Vishrampur, and in Vishrampur there is everything like trees, market, quarter, station, etc.
उन्नीस में जो लिखा मिलता है कोयला मिलता है यहाँ पर कोयला नहीं मिलता है दोनों जगह में की कीमत में
Underground में कोयला से क्या लेना देना है? It has got no relevance, right? Underground में हीरा मिलता है, इससे कोई फर्क नहीं पड़ता. Okay. So your most important document is Exhibit D.
Yes.
So let us see Exhibit D. The learned counsel, while referring to the evidence of the witness number 2, has submitted that he has exhibited the manner in which the compensation was quantified at the relevant point of time in way back in the year 1976, which is Exhibit D. Exhibit D दिखाइए. Exhibit D तो पढ़ा ही नहीं है.
सेवेंटी सेवन के इसमें लिखा है प्रमाणित किया जाता है तो पेज नंबर 1 से 15 तक दिए गए खाता द्वारा एवं रकबा को राजस्व पंजियों पंजी 2 लगातार खतियान एवं खतियान सर्वे से जांच किया सही पाया एवं स्तंभ 8 से 15 तक राजस्व पंजियों के आधार पर हस्ताक्षर रैयतों के नाम दर्ज किया जो मेरे जानते एवं राजस्व पंजियों के आधार पर सही है. जो कर्मचारी अंचल बुढ़ू नीचे है सर्टिफाइड दैट द रिपोर्ट ऑफ हल्का कर्मचारी हैज बीन वेरीफाइड फ्रॉम द रजिस्टर्स एटसेट्रा एंड फाउंड करेक्ट.
The learned counsel has submitted that as per the report, the property involved in this case was tar 1, tar 1 and tar 2. 13.5. पता नहीं चला.
That is not found.
That is not come. Anyway, this कुछ होता है. और क्या क्या कंसिडर
और
हुआ है?
इसमें भी एक बार भी टाइप ऑफ लैंड पे भी इन्होंने कभी
हाँ, कोई आर्गुमेंट ही नहीं. You just tell us that which sale deeds have been considered as per this. Is there any reference of any sale deed? Is there any reference of any sale deed in Exhibit D? Do you have any idea? Have you seen it or you have not seen it? No sale deed has been referred? You tell us, madam, in Exhibit D, is there any sale deed which has been referred? Sale deed, rate, कुछ लिखा? नहीं लिखा.
इसमें है प्लॉट एरिया एक्वायर्ड बाय सीसीएल क्लास ऑफ लैंड साइट है. That's it. page number 114, the name of Vishnu Dayal Song organization, his land.
Yes, his name is there, but there is no sale deed as such referred
No,
in this exhibit D.
no.
Correct? During the course of argument, the learned counsel for the appellant has not been able to show reference of any sale deed from exhibit D, much less the rate at which the compensation was to be paid. कुछ नहीं है इसमें, नहीं है ना? The learned counsel, however, suggested that since the claimant had raised the grievance with regard to quantum of compensation, still it was for the claimant to produce documents in support of their claim. And the onus was heavy on them, which they failed to discharge.
And the entire reliance by the court below has been made upon a judgment for Bachra Colliery, where the land was acquired in the year 65, and the award has been enhanced.
The learned counsel has submitted that the impugned judgment has been passed by on the basis of Exhibit 1, which is in relation to Bachra Colliery, which was acquired way back in the year 1965.
And that is a judgment. It is not a sale deed.
Based on judgment.
Based on judgment.
Based on judgment. She has submitted that merely because she has submitted that the judgment as such could not have been taken into consideration for quantifying the compensation in the present case. And admittedly, Bachra Colliery was around 13 kilometers. 13 bola na? 12 kilometers away from Vishrampur village. There is one more thing you can have a look.
Exhibit E is ladyship the order sheet.
Yes. The learned counsel has also relied upon the order sheet of the compensation case and has submitted that the order sheet is accompanied with the compensation chart. And the compensation chart gives the classification of different categories of land, and the rate has also been mentioned therein. ये टार वन टार टू का रेट कहाँ से आया?
उस समय का sale deed जो बोले कि consider that has come in my deposition. They are not cross-examining me on that part.
Sale deed ought to have been produced in the reference case. Reference case is not an appeal of the original award.
The learned counsel has submitted that during the evidence, the witnesses on behalf of CCL have stated that compensation was prepared on the basis of sale deeds, but there is no cross-examination. However, even the compensation chart does not refer to any sale deed. It only gives the rate with respect to different categories of land. क्या रेट है? सर्कल रेट है क्या रेट है?
rate of amount. Circle rate. Okay, I cannot say ownership, but car 1, 1250 rupees itna has been considered for his place.
Per this one.
2175. That comes to 2175. Car 3, 1233. That's car 3 again 742.
कुछ उस टाइम सर्कल रेट नहीं चलता था कुछ
The learned council has also submitted that even the computation with respect to different categories of land has been given. That's all. How about you?
So my contention is that in absence of any sale deed, we have produced our document that was acquisition of nearby lands, and in absence of any exclusive proof of sale deed, ownership of the area, the court has rightly discharged us of our onus. We had proved by bringing on record the Bachra Colliery, KD Colliery acquisition rate. On that behalf, it has granted us compensation. And ownership,
It has granted you compensation on the basis of Exhibit 1.
Exhibit 1, ownership.
Yes.
Exhibit 1 and 1C also, ownership.
I think 1 is the only document.
Acquisition case का जो भी है, ownership. There are 1, 2.
How many exhibits did you produce?
Exhibit 1 is judgment of FA 237 to 284.
Okay.
And my judgments may kindly be reflected in the order.
You just give a list with a paragraph. I
Yes.
just
Second thing, what I was saying, Lordship, if at all CCL had relied on any sale deeds, they ought to have produced that in the reference case. Since reference case is not an appeal of the collector's amount, every document has to independently be produced before the reference officer.
The learned counsel for the respondents has submitted that though the witness of CCL has stated that the compensation was fixed on the basis of sale deeds, but the material produced before the court did not include any sale deed. He has also submitted that there is no reference of any of the sale deeds in any of the documents exhibited on behalf of the CCL. The learned counsel has further submitted that in order to assess market value of compensation, the sale deed was required to be produced by CCL as the same was required to be compared with respect to the acquired land, both in respect of time and in respect of area and the location involved in the case. In absence of sale deed being produced or referred to in the documents, it appears that CCL, the compensation has been fixed without any basis whatsoever. यही आपको नहीं?
Yes, sir. Lordship.
अब exhibit 1 में.
Exhibit 1 is certified copy of judgment FA 237 to 284. Passed on 8/1/2004.
The learned counsel has referred to Exhibit 1, which was in connection with village Bachra. And admittedly, the land was acquired by issuance of notification under Section 4, which was dated 23/12/1965. The learned counsel submits that the distance from Bachra, as per the evidence, is around 12 kilometers.
2 kilometers and 7 or somewhere it is been stated 7.
कहाँ से 7
7 collieries जो other collieries है 7 से 8
7 to 8
that
kilometers.
relation is taken.
and 7 to 8 kilometers from other collieries. And considering the time of acquisition and the location, Exhibit 1 was the closest amongst all. And in absence of any other sentence having been exhibited on behalf of CCL, the learned court has rightly taken into consideration Exhibit 1 for the purposes of quantification of compensation.
We were discharged of our onus and now the onus was upon CCL.
The learned counsel submits that once the judgment Exhibit 1 was produced, the claimants had discharged their onus in the best possible manner they could have, and therefore the onus shifted upon the CCL to prove that the compensation was fixed by taking into consideration other sale which were closer and proximate and of similar nature as that of the acquired land. और बताइए कौन सा further? That should be sufficient.
Yes, Your Lordship.
The issue for development cost also I'll be providing the judgment.
Development cost will be applicable to
Acquisition under this is for immediately acquisition. It doesn't apply to this. इसका कोई relevance नहीं है. Development cost will have no value. The learned counsel has also relied upon Exhibit 2, Exhibit 1 by A, and has submitted that in the said judgment passed by this court, it has been observed that the previous judgment must be relied upon, but attending circumstances should also be considered. The said judgment is in relation to land acquired in the year 1986-87 with respect to property situated in कहाँ पे है कौन सा क्वालिटी का है कौन से क्वालिटी का है with respect to adjoining quality. यही बोलेंगे कौन से क्वालिटी का है Exhibit 2
Exhibit 1
तमाम
by A.
क्वालिटी तमाम क्वालिटी विलेज तमाम पुलिस स्टेशन खिलाड़ी डिस्ट्रिक्ट ब्रांच में He has also referred to Exhibit 1 by B, which was in relation to lands acquired by notification of the year 1986 and was also for village Tamam PS Khilari district branch. The learned counsel has submitted that the Exhibit 1 was closest to that of the acquired land, and by the Exhibit 1, the rate was fixed as it stood in the 1965, and in the present case, the acquisition is around 10 years after
That's true.
Exhibit 1. The learned counsel has submitted that by referring to Exhibit 1, which was much in prior to time, the claimants have not gained any additional advantage. Rather, they were referring to lands acquired much prior to the acquisition involved in the present case. And consequently, they have been in slightly disadvantageous position by referring to the acquisition of the year 1960. थोड़ा सा तो डिसएडवांटेज है 10 साल का. अपना अपना जजमेंट जो है रेफर कर दीजिए.
But regarding Solatium, I would like to refer a judgment. In this case also, land was acquired in the year 1980, notification was received in the year 1989, yet Solatium and interest was granted.
The learned counsel, with respect to the claim on solatium and interest, has referred to the judgment passed by Honorable Patna High Court, reported in AIR 1998 Patna, page 100, and has submitted that in this case also the acquisition was prior to issuance of the notification issued by the Union of India in the year 1989. And therefore, there can be, and in this case, solatium to the extent of 30% and interest
9%
9%
for first year.
for first year and 15% for subsequent years have been granted. And in the present case, kitna interest कुछ भी नहीं है.
Interest or Solatium कुछ भी नहीं.
The learned counsel has submitted that in the present case, no amount has been awarded relating to interest and solatium. That's all. Okay?
I've given the copy, but I'll provide
Please
my.
give me the copy also. And you have referred to the paragraphs?
Yes, yes.
ये फर्स्ट अपील नंबर ये कौन सा जो मैंने डिसाइड किया ये वाला
Yes. These are all the judgments.
The learned counsel for the appellant has referred to following judgments. दे देंगे प्लीज पांच दे देंगे ये पंकज जी
And there
और
is
आपका
one
कोई रेफरेंस
MA matter, Milord, which I have not mentioned there.
हाँ.
This yesterday. This
ये
is
साथ में लगाइए एमए
ये भी
पैराग्राफ नंबर बताइए
उसमें काना लिखा सब
सब
बस
ये ना
उसको-
एमए वाला भी उसको लिख दीजिए ना प्लीज प्लीज राइट इट
MA I am just writing.
You just write it because they will type it कुछ छूट
Yes,
जाए.
yes, yes. Ladyship, since it was for my consumption, my that
कोई बात नहीं, it's okay, no problem. जजमेंट में कैसे बोले हैं कि the sale deed was also considered?
जजमेंट में बोले हैं दूसरे केस में रिलाई करते हुए कि उस केस में सेल डीड वाज आल्सो कंसीडर्ड दैट आई आल्सो गॉट टू यस्टरडे आई हैव मार्क्ड दैट पार्ट आल्सो
Where is that?
यस
क्योंकि जजमेंट में बोले हैं कि
हाँ
considered.
जजमेंट में उसको that is Page number 10, Leadership,
Yes, I'm at page number 10.
of the judgment. Yes. However, this is the case. I'm just reading that paragraph. And यहाँ से नहीं clear होगा. Exhibit E is the land of such and such calculation. Just one page prior. Land acquired by Tar Paddy Village and others, and the amount of the land acquired by the claimant was rightly fixed to rupees 21431 for 6.01 acres of land. Land was acquired under CBA in the year 1976 by notification such and such. And at that time, land was barren land, and according to the nature of the land, compensation was evaluated by opposite party, which was proper. Claimant has not produced any document to show market value of the land acquired. At that time, the acquisition of the opposite party for the land acquired in the year 1976, no solation system and interest 15% was applicable. Learned counsel for the opposite party placed his reliance on the decision of the Honorable High Court of Jharkhand Ranchi passed in miscellaneous appeal 50 of 1995 and others on 10/11/2004, Union of India versus Vishnath Prasad and others, in which Honorable Court has observed that, however, considering all the facts, letters and evidence of the witnesses produced on behalf of the claimant, as well as the evidence of witness produced on behalf of the opposite party, and considering the sale deeds brought on record by the sides, I am of the view that the determination of the price of the land on the basis of classification does not appear to be plausible and workable, and at the same time, price of the land assessed by the tribunal is not found to be proper. I reduce the rate of compensation from 727 per decibel. So in some other case, that part has been quoted. और पूरे ये में बस इसी जगह पे कोई sale deed refer. In my deposition, that has been mentioned कि किसी sale deed के आधार पर किया गया, and now this is in the pending.
No, किसी सेल डीड के आधार पे किया गया, लेकिन वो कौन से सेल डीड के आधार पे किया गया, it is not there.
No,
Neither in your documents,
no, it is not.
nor in your deposition.
Yes, it is not.
Date, area, कुछ भी नहीं.
Yesterday, Lordship had asked if we had filed a written objection while getting the award, Lordship. This is the written objection dated 78. In the year 1978 only we had filed an objection while receiving the award.
Award तो आपने 2001 में रिसीव किया.
उसके बाद फिर दूसरा रेफरेंस केस चला था Lordship 9 of 98. हम लोग
These
objection
are
से
कुछ भी
पहले
record
इससे कोई फर्क नहीं पड़ेगा.
These are not at all.
एक आदमी ने बोल दिया ना objection किया. दो विटनेस में से एक ने बोल ही दिया. And jointly they are claiming so far as this property is
the original awardees had filed the objection.
मेरा चार्ट दीजिए इसका जजमेंट का डेट चाहिए.
Well, file a list of judgments just now.
अभी तुरंत दीजिए, नहीं तो बाद में नहीं लेंगे.
तुरंत दे रहे हैं.
पैराग्राफ नंबर किस पॉइंट पे देना चाहिए, किस पॉइंट पे देना चाहिए.
मुझे ये सोलेशियम को लेकर एक और जजमेंट है जिसमें सोलेशियम को रेट्रोस्पेक्टिवली अलाउ किया है सारे केसेस.
आप दे दीजिए.
But strangely enough, they are talking all about the sale deed that we did not produce, based on which it was the compensation was.
वो जजमेंट का खोज के नहीं लेके आए.
और
they
ये
are also they also have some responsibility.
और ये जो है
वो हमें खोज के डालना पड़ेगा. एक मैंने जजमेंट पे रेफर्ड है, वो आप खोजे भी नहीं, देखे भी नहीं. हम आपको बता दिए थे कौन काउंसिल आपको बताएंगे, आप उनके पास गए भी नहीं. हाँ?
I approached the senior counsel yesterday. I'll try approaching him.
He didn't tell you.
He said he is not remembering. He will forward it.
जब आएंगे तो हमसे पूछेंगे, दुनिया को जजमेंट नहीं बता.
और ये खुद अपने केस में एक भी सेल डीड लेकर के नहीं आए to substantiate the enhancement.
जो सीनियर जूनियर को जजमेंट नहीं बताते हो उनका केस एडजर्न. He has been citing that judgment in number of cases. उनको by heart याद है. बोलिएगा कि हम जजमेंट खोज लेंगे. उनको कॉपी दे देंगे तभी आप फर्निश करेंगे. अभी आप लिस्ट ऑफ जजमेंट बताइए. आप दे देंगे?
Yes.
goes for judgment on 4th of July. Within 2 months हो गया?
उनका पूरा कंटेंशन भी हम सेव नहीं करते, पूरा एनहांस करा दिए विदाउट एनी सेव।
चल। सोचे थोड़ा क्लोजली देखना जरूरी है, ऐसे नहीं कर सकते, इसलिए एविडेंस वगैरह साथ ही साथ नहीं कर सकते। मेरा 60% काम हो गया।
From hearings for final disposal item 1, second appeal 309 of 2016.
Yes, please. Where is he? आप हैं इसमें other side. Mr. Sharma, are you there in this case?
Yes.
बताइए. For respondent?
Yes.
तो छोटा सा क्वेश्चन ऑफ लॉ है, क्या बोलना है?
लेकिन ये क्वेश्चन ऑफ लॉ पर तो ये अपील अलाउ
अलाउ नहीं होगा।
इस अपील पे इस क्वेश्चन ऑफ लॉ पे करना, क्योंकि इसमें कोई लीगल ऑर्डर
हम तो सिर्फ क्वेश्चन ऑफ लॉ ही जानते हैं।
ऑर्डर 41
उसके बियॉन्ड तो हम नहीं जानेंगे।
ऑर्डर 41 रूल 31 पे जो पैरामीटर्स है उसके लाइट में इन्होंने पॉइंट ऑफ डिटरमिनेशन फ्रेम किया और अकॉर्डिंगली आंसर। कोई दूसरा क्वेश्चन ऑफ लॉ नहीं।
ये दिखाइए जरा एप्लेट कोड का जजमेंट।
राइट और ट्रैवल रूल से रिलेटेड
एप्लेट कोड का जजमेंट दिखाइए। पहले ट्रायल कोर्ट का इश्यूज दिखाइए, फाइंडिंग दिखाइए। जो पॉइंट ऑफ लॉ है वही जानेंगे ना हम लोग, उसके बियॉन्ड नहीं जानेंगे। आई एम नॉट सपोज्ड टू नो बियॉन्ड दैट।
देखा जाएगा पार्ट ए।
पहले थोड़ा ट्रायल, आप किसकी आप क्या हुआ? कोई बात नहीं, इनको सुन रहे हैं ना। ऑर्डर फॉर क्या प्रपोज उनको दिखाइए, वो आगे हैं। तो पहले तो ये मान लीजिए कि जो बना है उसको नहीं चलेगा।
है प्रॉब्लम है। Why to unnecessarily?
अगर मान लीजिए अगर
जो प्रॉब्लम है, I do admit your lordship at the time of admission, but your lordship may only see these questions.
I will see that.
Yes. If they are involved, then your lordship may frame it. That is
frame it and fix it. ठीक है, यही तो करना होगा।
हाँ।
और उनको बिना सुने तो नहीं फ्रेम कर सकते।
हाँ।
बताइए क्या है?
This is first one is your lordship, whether the alleged custom among Santhals, it would not be tribal, it would be Santhal. Because Santhal
वो करेक्शन भी हमें को करना होगा।
Santhals debarring female from their right of inheritance over the land left by ancestors satisfies the test of binding custom as has been laid down by in the case of Lakshmi Bai versus Bhagwan Guha in 2013 volume 4 SCC 97. It is not 1997, it is only 97. Second is whether the first appellate court was right in reversing the judgment and decree of the trial court and holding that the plaintiffs were admits and had the right of reversion despite finding that the plaintiff had failed to establish direct relationship between the two brothers. Now why I say, your lordship, this is directly based on a High Court, Patna High Court judgment full bench of 1983, where the Honorable Court full bench held that a person who is claiming right of reversion has to establish each and every link. And here the appellate court, though it finds that it has not been proved, only on the basis of surmises it holds that they have a right of reversion. Now whenever a right of reversion is claimed, that means the natural succession to the natural heirs is said that they are not entitled to succeed and therefore the property would revert back to them. That is the ground on which the reversion, right of reversion is claimed. Now if your lordship would see this 1983 Patna, page 146. This was approximately 60 pages, therefore I did not take out a printout.
Patna page number?
Para 146.
Page number?
Page number is 93.
93. Para 140.
146.
We'll take your words as it is. What about third?
Now, third is whether because it was a judgment of reversal, they were the original plaintiff, they filed a suit. Their whole suit was based on that we being descendants of the original recorded tenant was not disputed by them. They only said that the original person, he only left behind one Joba Murmu, who was a daughter, and therefore she did not get the property, and the property would not go down to her successors. The property would now revert back to the other reversion. That was the entire case. So, our being the descendant of the original recorded tenant was not in dispute. The original trial court, it dismissed the suit filed by the plaintiff, claiming the right of reversion. It dismissed the suit. Appellate court makes out cases which the plaintiff, being a plaintiff, he was required to do, not me being a defendant. Then also it shifts the burden on me to prove that I was married in Ghar Jamai form and all those things. In our written statement, we took a very specific stand. Two stands were taken, alternative. First, it was said that the mother, Shobha Murmu, was married in Ghar Jamai form. Then also it was said, relying on the Ganjar survey report, it was said that he had taken note and even otherwise the daughter was entitled. These two plea was taken. In the written statement, fortunately, Your Lordship, the pleading was there. If this pleading would not have been there, I would have had difficulty. But this specific pleading was there that the female, otherwise also she was entitled to be.
Under Santhals. Is it
Yes.
an admitted fact that you are governed by Santhali law?
Question
Yes.
That is an admitted
Yes,
fact?
yes. There's no dispute with it.
That both the parties are governed by
Yes.
customary law under Santhals.
Yes.
So far as the question of law which my friend
Just a
wants
moment.
to put forth. First question of law does not apply. Because the judgment which my friend is relying, it is on a family and personal law of Hindu law. So Hindu law, it does not apply to murder. Hindu or Mohammedan law does not apply.
No, it is not saying that. It is saying that how the custom is to be proved.
So far as the custom is concerned, that the law is well settled. First and foremost requirement for a custom should be that it should be pleaded. And there must be certain evidence on records. But so far as this case and hand is concerned, and because there is no dispute that the parties are governed by the custom and that too by the customary law. The Hindu law will not apply, neither the Mohammedan law, any other law except the customary law under the tribal will apply. So, it is not in dispute.
So
Now
you are the plaintiff.
I am the plaintiff.
You say that they are governed by customary law.
Yes.
In order to prove that under the customary law
Yes.
or under the customary law of Santhal,
Ma'am.
the daughter or the married daughter
Yes.
has no right over the property.
Yes.
What is the
No right, I don't say. They have the right. But
they-
as
they
per
are
the
plain
custom,
and
text.
to
they
what
have the right.
extent
That is the basis.
and to what extent they
Yes.
have the right?
They-
What is the evidence you have brought on?
Yes, there are several gazetted settlements report and all other reports are has been considered that under what occasion and under what circumstances a daughter of a recorded tenant can have a right. The first and the foremost requirement.
Which all I have just
Which has
asked
all
you to
been
furnish
considered.
also, but you have not furnished those things.
That
Up to line in
वो
settlement.
इसमें
So
है,
these two, these
इसमें है,
settlement,
इसमें है.
this settlement has been considered.
yes, everything has been considered. So
Let
far
us-
as the appellate court judgment, your lordship is concerned.
First, Your Lordship, allow me to place, then
Let me say so. But so far as the question of law which has been framed, your lordship, that has already been answered, and it has been answered on each every point. My friend was saying that the evidence has not been considered. That is not the case. Your lordship.
So let me go on.
Yes.
Once the custom is to be proved,
Yes.
right? In order to prove the custom, you have referred to various.
Here there is an additional case, Your Lordship. Both the parties are my lord, admitting that it is governed by the tribe. Here in this
Yes,
particular-
yes, there is no dispute
Yes.
on that.
Yes.
There is
I'm
no
not
dispute that you are
Yes.
governed by customary law.
I-
But the point is, what is the custom?
Yes.
And how do you
Yes.
prove it?
Yes. The custom, Your Lordship, it is my lord, it-
No, we are aware what is the custom in general.
Yes.
I want to know whether it has been proved.
Yes, yes, I will say.
What all are the evidence on the basis of which it has been proved? Now, once you say this,
Yes.
I will ask them what is the perversity in the matter of consideration
Yes.
of this law.
So far as the appellate court judgment, Your Lordship, is concerned. My lord, the point of determination which has been sent, Your Lordship, may kindly have it for attend. For attend, Your Lordship, may kindly.
Para 10.
Yes,
Yes, please.
at the internal page 10. Internal page,
Yes, I am
running
there.
page, running page.
Yes.
After hearing the party, did my lord know? After hearing the parties and gone through the pleadings and materials on recorded mind, that there are three prima facie questions, prime questions involved in the dispute between the contesting parties and in the present case. First question is whether the Joba Murmu, daughter of recorded tenant Arma Murmu, put in her Jamai form of marriage with Kanu Hasda of the village Kalipur, Ranga, P.S. Jama district. Second question is whether the Harma Murmu and Tikat Murmu were full brothers and the present plaintiffs being descendants of Tikat Murmu are kindred and agnates of the recorded tenant Harma. Third question, whether the suit property in the name of Johan Handa, Yakub Handa and Peter Handa, all sons of Galu Handa, in the recent record of right, exhibit D or 4 by the new father number 10 of Moja Mangurdi on the basis of Yada, exhibit 447 prepared by Service Settlement Authorities of the recent service settlement, in which defendant number 1, Ismail Hasda, shown documents and claimed before the settlement authorities that his father Golu Handa is an adopted son of recorded tenant Murmu, who had 4 daughters. My lord, our stand, Your Lordship, that my lord, this settlement, Your Lordship, has been illegally made on the basis of my lord, claim that Galu Hasda was adopted son. They have taken shifting, they have taken very specific stand that the husband of the Joba Murmu, she was a Ghar Jamai. But my lord will find that there are exhibits that have been considered by the appellate court, that my lord, they are having their rights in the village that is Kali Rangapur. Those properties are still in their name. Those documents we have. My lord,
Is it necessary for a Gharjamai to relinquish his
yes,
rights
that
under
is
the...
well said. That is well said. Once you become a Gharjamai, then you cannot claim property in the ancestral property, your original.
You have to give it up.
Yes.
You have to give it up.
You have to give. You have to give.
Relinquish.
You will have no claims.
कौन सा judgment?
There are. पारा 14 में रेफर्ड है ये चीज इन्होंने कंसीडर किया है वो चीज सेटल्ड वो सब चीज में माय फ्रेंड विल आल्सो नॉट
Only one thing, Your
question
Lordship.
is otherwise.
Firstly, I was praying that the questions of law which are proposed by the
Provided it
claim,
arises.
for that I may be allowed to place only 2 things. For the first question, Your Lordship, which I placed was based upon Lakshmi Bai versus Bhagwan Pura. What it says, Your Lordship, may kindly allow me to read. And this is the book which I am. This what is requirement of a valid and binding custom, that Your Lordship may
the custom that you will be entitled for property is marriage through Gharjamai form. This custom itself is not in dispute, it appears.
No, not with regard to that. I say that let us assume that there was no ghar and the marriage was not in the form of ghar. Let us assume their case also. And it was in ordinary form. Whether under ordinary form, whether the daughter would have a right to succeed to the property or not, and when there are absolutely no one in the family, she is the only one. So whether she would not have a right and then the property would revert back to the Agnes. This is the question which I am raising. So here the entire pleading of the plaintiff is that the daughter does not have any right. This is the basic of the pleading, and he is the plaintiff. He said that the daughter would not have any right. So he has to prove that daughter did not have any right. So here this particular judgment, Your Lordship, it was mentioned, para 12 and two paragraphs only I'll read, and then I'll show the Ganges survey which is being time and again being relied by all the courts. Yes, Your Lordship may see para. And 14, I may be allowed. Custom is an established practice at variance with the general law. A custom varying general law may be general, local, tribal, or family custom. A general custom includes a custom common to any considerable class of person. A custom which is applicable to a locality, tribe, sect, or a family is called special custom. Custom is a rule which in a particular family, a particular class, community, in a particular district has, owing to the prolonged use, obtained the force of law. Here, this is the portion which I am relying. So, has, owing to the prolonged use, obtained the force of law. Custom has the effect of modifying general personal law, but it does not override statutory law unless the custom is expressly saved by it. Such custom must be ancient, uniform, certain, continuous, and compulsory. No custom is valid if it is illegal, immoral, unreasonable, or opposed to public policy. He who relies on custom varying general law must plead and prove it. Custom must be established by clear and unambiguous evidence. Then para 14, a custom must be proved to be ancient, certain, and reasonable. I'll show all these things are not there. Ancient, certain, and reasonable. The evidence adduced on behalf of the party concerned must prove alleged custom and has to prove must not be unsatisfactory and conflicting. A custom cannot be extended by analogy or logical process, and it cannot be established by a priori method. Nothing that the court can take judicial notice need be proved. When a custom has been judicially proved, then so and so, so and so. So, Your Lordship, what I want to submit is that it has to be so uniformly followed that it has acquired on the force of law, and nothing beyond that can be seen. It is absolutely certain and continuously it is being followed. Now, Your Lordship, you may kindly see the Ganges report itself. What it says. It was absolutely not certain. Ganges report. Yeah, SPT.
It's recorded in the judgment itself. It has been considered in the judgment itself.
Ganges only
quoted?
only portion of it has been quoted. The learned appellate court only quotes a portion of it. Therefore, I wanted to place this here. इसमें होगा क्योंकि ये तो इस पुराना वाला इस मल्होत्रा में है. हम एक बार निकाल दें. Ganges report abstract.
What is Santhal Christian law? What is Santhal Christian law?
Santhal,
Christian law.
Christian law, there is no such. It is only Santhal.
ये कैसी है ये?
They संथाल में अलग दे संथाल एंड ट्राइब दे
अभी देख रहे हैं ना नया नया जजमेंट आ रहा है.
हाँ ये
अभी आ रहा है ना नया नया जजमेंट.
हाँ
Convert will lose the status of SC/ST. This is the latest. आंध्र प्रदेश से आया. Now Kerala से भी आया. That in certain religious communities there is no concept of any caste. He is Santhal Christian God. इसका क्या मतलब? Tell me. This is your case.
ट्राइबल लॉ में इसका reference है. इसी राय छोड़ी. So far as the law is concerned, Christians Santhals are governed by ordinary Santhal law. Santhals belong with Munda, Ram, Bhog,
ये क्या चीज़ है?
Special Officer Gadgettier Revision Section Revenue Department Bihar Gadgettiers. Compilation ही किसी राय चौधरी compilation.
ये सब किताब से नहीं चलेगा.
आने चाहिए लेकिन
Annotation, commentaries से नहीं चलेगा.
संथाल परगना इंक्वायरी कमेटी 1938 का W.G. आर्चर का उसमें वो हमको लगता है नारायण और सोरेन वाला जजमेंट जो है जस्टिस मुंबई इकबाल का वो भी उसमें भी कंसिडर.
That converts will be governed by ये judgment निकलेगी.
ये वाला it is not there in the chips. I'll just refer to this.
आप लोगों को तो बोले थे सब फाइल करने.
नहीं ये मेरे को लगा ये बहुत कॉमन बुक है इसी के लिए अदरवाइज आई वुड हैव डन. This was by Malhotra's. It contained the Ganger's report. And this is the portion on which all the courts rely.
ये कौन सा पैराग्राफ में बोल रहे हैं? Santhals who are following Christianity will be governed by customary law. Which paragraph are you referring to? आपने देखे हैं लेटेस्ट एविडेंस?
Santhal ka Christian.
The person, the moment a person is converted, he is not governed by SC/ST.
Yes, he would not be governed by his original customary law.
क्योंकि जैसे कन्वर्शन हो जाता है, मैरिज, adoption, inheritance, etc. are governed by their own church or by their own system. Suppose a person gets converted into Islam, then his inheritance will become governed by Muslim law. Similarly, a person who gets converted into Christian, his inheritance will be governed by that law.
Yes.
अभी लेटेस्ट जजमेंट्स है इस पर आपको
हम बाकी देखेंगे
क्योंकि ये ओपनिंग इनका केस है
हाँ
कि that
opening
they
है।
are governed
Exactly.
by Santhal
एकदम,
is
एकदम।
ordinarily according to an ordinary married Santhal Christian couple.
हाँ,
Maybe it's not defined.
I'm not denying it. So whether
नहीं ऐसा है ना कि जब कोई चीज आएगा और आप एडिशनल क्वेश्चन ऑफ लॉ की बात करेंगे तो हम लोग हर चीज देखेंगे.
Parties have come with.
No, he has said that he filed a written statement saying that क्या है आपका written
He has not
statement
said
में क्या?
that we are not governed by the tribal custom.
नहीं, let us see what is his written
Let us see
statement.
हम बोल रहे हैं दोनों में entitled है, ये हम बोल रहे हैं.
ये
And a
ऐसा ये
person-
बोले इसीलिए हम
A person who says that I am not entitled, he has to show
What he
that.
is saying, he is saying a different thing. What he is saying.
written statement पढ़िए ना फिर different
पढ़
और
दे।
क्या different
पढ़
कुछ
दे,
पढ़ना ही नहीं है उसके अलावा.
पढ़ दे. पैरा 9
पहले इनका स्टेटमेंट पढ़.
हाँ पहले इसको पूरा हम पढ़ देते हैं. बेटर है हम पूरा पढ़ देते हैं और इसमें मेरा जेनियोलॉजी कहीं डिस्प्यूट में नहीं. That the plaintiffs as well as the defendant first party and pro forma defendant belong to Santhal Christians by caste and they are governed by Santhal customary law in the matter of inheritance. That neither Hindu law nor Mohammedan law is applicable to the Santhal Christian community.
एक सेकंड, let me just get my plate.
He is reading plain.
हाँ, yes, we are reading the plate. जब हम लोग लॉ की बात करेंगे तो प्लेन से ही चालू होगा. हम तो कोई सेकेंड अपील भी बिना प्लेन पढ़े डिसाइड नहीं करते. हाँ बताइए.
Yes. That the plaintiff as well as defendant first party and the pro forma defendant belong to Santhal Christians by caste and they are governed by Santhal customary law in the matter of inheritance. That neither Hindu law nor Mohammedan law is applicable to Santhal Christian community. That according to Santhal Christian customary law of inheritance and ordinary
Santhal Christian customary law.
law of inheritance. There is no such separate
आगे आगे.
Christian law of inheritance. An ordinary married Santhal Christian daughter of a deceased Christian Santhal is not at all entitled to inherit her father's property. So here the entire case is there. So they admit that there was a daughter, but she would not have been entitled. This is the entire crux of it.
ये the entire pleading is Santhal Christian community.
Yes, yes, yes.
What is a new kind of community that you have created?
No, it is not there.
And
There is
what
no
is your
such.
response to this?
It is responses. And then they also say only few further lines here.
Yes.
In such a case, if a sonless Santhal Christian dies, his property will pass on to his agnates, and his agnates shall be entitled to inherit his movable and immovable properties after his death. And then next page, your lordship may see, this is the major dispute. Karu Murmu, according to their case, Karu Murmu had two sons, Tikat Murmu and Harma Murmu. And Harma Murmu's genealogy is not in dispute, right sir? Harma Murmu had a daughter named Joba Murmu and who was married with Kanhu Hansda, and then he had a son Galu Hansda and their descendants are the dependents. This genealogy is not in dispute. And the fact that Harma Murmu was the recorded tenant is also not in dispute. Entire property, which is the suit property, stands in the name of Harma Murmu.
Still.
Only, yes, exclusively. Now what they say, that Tikat Murmu was the brother of Harma Murmu, and then they say that because Harma Murmu died leaving behind a daughter, therefore daughter would not have a right, and therefore the property would revert back to me, that means I am the brother, and this branch they claimed. We disputed this fact, that there was any brother named Tikat Murmu, of Harma Murmu had any brother, this was disputed, and the case was obviously dismissed by the trial court and it has been upset by the first appellate. So this fact that Tikat Murmu was brother of Harma Murmu was another very important fact, and therefore I had relied on this is second substantial question of law is there, in which the Patna High Court full bench has held that if a person who is claiming reversionary right, he has to establish each and every link from the original
So
person.
he is establishing, because you say that this is not in dispute.
No, what is not in dispute is Harma Murmu had a daughter and all those things, but this is we are disputing that Harma Murmu had a brother named
This is
Tikat
disputed?
Murmu. This is disputed.
No, later on amendment has also been brought.
I'll
That
come
is-
to all those things. I'll not.
We are as to whether an additional substantial question of
Question
law
of-
is to be framed, and what would be this additional substantial question of law. We are only on that.
So therefore, Your Lordship, this is related to the second substantial question of law, where the Honorable Patna High Court very clearly, if Your Lordship would see that only 3-4 lines of Patna High Court, only 4 lines of para 146.
You want to say that it has to be established.
Absolutely, the Honorable Court says that each and every link has to be established.
So we'll see
The
that.
moment the court, a person claims reversionary right, he has to establish each and every link from the original law. So here exactly
Let us
this
see
was the situation.
Let us see the entry was also made in the name of Johan Hansta, because the decree declaring the entry in the land khata number such and such in the name of Johan Hansta.
Yes, he was the descendant of Harma, that means the grandson of Joba Mohan. This
So if he is a
This is being disputed by them, therefore they had challenged, filed a suit for that it was wrongly recorded in the name of Johann, Jakub and Peter. It was wrongly
when
recorded
was it recorded? Any time of entry?
in subsequent survey.
Okay.
In original survey,
So it was Harmu Murmu.
yes, and in that, in the remark column, the name of the grandson, that means Galu Hansda was mentioned.
As a Nati right?
As Nati, yes, yes, as Nati.
There is a custom prevalent in them, job tajim, that is for a temporary period only.
Merely
And what is the claim of the defendant is, plaintiff is, that had he been a Garzamai, then his name must have been there. And not only that, rather the properties which are at the village Kali Ranga, the Rangpur, that is in his name. And all these grandsons also.
What
They
we say,
want to claim this property as a Garzamai and also not relinquishing the property or rather enjoying the property as village Kali Ranga.
para 9,
That
Your
has been
Lordship.
taken not by them.
We are only on the question whether the questions of law which I have proposed may be formulated on.
So far as the
Para
factual
9 of
aspect
my
is
written
concerned,
statement may be seen.
so far as the factual aspect is concerned, that has been well taken not by the applicant.
I may be allowed to first make my
Yes.
submissions. Then Your Lordship may see, Your Lordship wanted to know what was my written statement. Para 9 I am directly quoting that the statement made in para 3 of the plaint are only
You
partly
read para
correct.
7 also.
Yes, para 7. I'll read the entire paragraph. That with ulterior motive the plaintiffs have falsely described defendant number 1 and 2 as residents of village Kalipur so and so, and their father and paternal uncle, grandfather Galu so and so were born and the village Mangrudi, and none of them lived at village Kalipur. So why this statement was made that Kalipur was the village of the natural parent. This is their claim that it was Hansda's natural.
Kindly read para 7 also.
Yes. Para 7. That the statement made in para 1 of the plaint is only partly correct. The correct fact is that Harma Murmu, son of Karu Murmu and his daughter Juba Murmu and her husband Kanhu Hansda were not Christian, and it appears that it was Galu Hansda, the grandfather of defendant first party, had become Christian, and since the family of defendant first party are Christian, that the statement made in para so and so denied. That the statement made in para 3 of the plaint are only partly correct. It is submitted that there is no Santhal Christian customary law of inheritance as stated in para 3. The correct position is that the Santhal tribal law of inheritance given in para 46 of the Ganjar settlement report also apply to Santhal Christian in the matter of inheritance and succession. From the said para 46, it would be evident that the law not allowing females to inheritance was changing owing to the force of public opinion even during the time of Ganjar survey and the settlement. And daughters not married in Ghar Jamai form also inherit the paternal properties and the contrary statement made in para 3 of the plaintiff. So here my case is very specifically we say that even as daughter we would have inherited. And then your lordship may see para 11, same page, last two lines. It is further submitted that Tikat Murmu was not the son of Karu Murmu as mentioned in so and so said case. So his being my cousin or brother of Harma Murmu was specifically denied. May I read further? The statement made in para 6 of the plaint are imaginary and false. Harma Murmu had no agnet or co-sharer and hence he never had any occasion to separate himself from his alleged agnet or co-sharer much before last Ganjar or any time. In this connection, it is submitted that before the wood settlement, Tikat Murmu and Harma Murmu had no concern with each other, which would be evident from the last settlement parcha of Jamabandi number 3 of Mauja Mangrudi, which belonged to plaintiff, corresponds to McPherson settlement number so and so, and McPherson settlement JB number 13 corresponds to Wood settlement 10. It may be stated that McPherson settlement Jamabandi number 13 was recorded in the joint name of 3 sons of Tikat Murmu, and the said Wood settlement Jamabandi number 10 was exclusively recorded in the name of Tikat Murmu, Tikat Manji. That in the that on the other hand, the last settlement JB number 30 of village Mangrudi as well as other corresponding McPherson settlement Jamabandi number 22 were recorded exclusively in the name of Harma Murmu alias Maji. That the statement made in para 7 of the plaint are partly vague and partly false. The plaintiff have motivatedly made a vague statement that the recorded tenant Harma Murmu of last settlement Jamabandi number 30 died sometime past.
She gives a written statement by saying the written statement was saying that firstly she is not Christian, the plaintiffs are Christian. Secondly, she says that she is governed by inheritance and refers to gangster settlement by saying that there is a trend. वो तो हम लोग देखे हैं. I do not know whether it has been considered, not considered.
Not considered.
That has not been quoted.
Only one portion it quotes.
ऊपर वाला portion
हाँ हाँ
नीचे वाला portion
दिखाएंगे वही.
देखे हैं हम उसको देखे हैं हम उसको follow भी किए हैं.
हाँ वहाँ लिख रहे हैं क्या? वहाँ the Ganjar that particular portion itself mentioned that it would be separately dealt with another paragraph. That another paragraph was never quoted. So therefore, your lordship, it was very clear stand of the defendant in the written statement itself that even if Ganjar report is taken into account, then the law was changing and daughters were being given rights.
This is one stand that you have taken.
Yes.
Did you take a stand that otherwise also you are entitled for inheritance?
Otherwise also?
Otherwise also. According to you, you are governed by Santhal law. You denied the relationship with him completely.
Yes.
You said that you are a Santhal but the plaintiffs are not Santhal. This is what you have said?
No. They say, the written statement is that initially they were not Christians. Subsequently, Galu changed to Christian and then Galu onwards. That means Joba was not Christian.
Joba was not Christian.
Yes.
They are claiming rights from Galu.
But Galu would not come out of anything
Galu-
separate.
Galu
Galu was the
Galu
son
they are
of
claiming, right?
Joba.
Galu is
Not son of.
no, not son of Joba. Galu is not son of Joba.
No, he is son of Joba. Your Lordship may see the genealogical table. Your Lordship has the genealogical table.
In the records of right, his name exists as Hagatu, not even Galu. But learned appellate court has said that they never said it is Hagatu. Only Galu, everywhere it is Galu. And as a Nati Rayat, he has been recorded. The specific consideration made by the learned appellate court, had there been any case of Gharjamai or like that, then the name of Kanu Hasda, who was married in the Gharjamai form, would have been recorded. This is one of the considerations. So far as the recording of Galu Hasda in the records of rights is concerned, we have specifically, by way of amendment, we brought this amendment that at the time of survey settlement, they had said that Galu Hansda was adopted, and on that basis entry has been made. Later on, they denied it, and those things have been.
Where is the name of Galu Hansa in the genealogical table?
Yes, it is the son of Joba. On the right side, your Lordship would find. Joba married Galu, and then both married in ordinary form. This is what they say, and then Galu is the son of Joba.
Maternal son.
Whatever it may be.
Recorded.
My being son of Joba was never in dispute, never in question. What was in question was whether ticket was.
Maternal son has come in the records of rights.
When you assert that the daughter is completely excluded,
Yes,
were you required to prove it?
those evidences has come.
No, not evidences.
Those
You
evidences.
see, the findings are based on survey settlements,
Findings of this-
survey settlement operations, gangster settlement and all that. Why selectively it has been proved?
No, question your Lordship is otherwise. My lord, so far as the tribal law is concerned, it is a well established custom.
देखिए वेल एस्टैब्लिश्ड के लिए तो आपको कुछ दिखाना पड़ेगा ना. वेल एस्टैब्लिश्ड आपके बोलने से तो नहीं हो जाएगा. आप कहना appellate court का दे.
Pronouncements are there. That
That
is
is,
another.
they are completely excluded.
There are circumstances in the gazetted settlement when they can be recorded. Those aspects have been considered by the
No,
appellate.
you are not answering my question. Your case is that the daughter is completely excluded.
My lord, my case, your Lordship, that my lord, if daughter is my lord, has been married in the Gharjamai form, then only my lord the Gharjamai
You forget about Gharjamai form. Suppose there is a daughter
Well,
and daughter is married and there is no Gharjamai form, but she is living there. Is she completely excluded?
as per the tribal law.
कहाँ से? You see, gangster settlement दिखाइए कहाँ?
Wait. Your Lordship may see the.
Your Lordship, may kindly see
Your
Your Lordship may allow me to.
You read it, please. Read it.
Page 11.
इसमें है?
Your
इसमें
Lordship
है?
may allow me to
इसमें
read
है?
and then.
इसमें है?
हाँ, उसी में last में ज्ञान जर्सी.
पेज 11 हम पढ़े हो जो इसका ट्राइबल लॉ का देखा जाए इस पे
Page 19
उन्होंने रेफर किया है अपने
Yes. Page number?
Page number is Your Lordship 91.
I'm at page number 91.
Page number is 89. Survey and settlement operations, Your Lordship.
Yes.
Your Lordship has got it.
Yes.
Yes. Your Lordship would find Santhal law of inheritance.
Santhal tribal law. of
Yes. Your Lordship may allow me to read, but
Yes.
this is the portion with the court, appellate court and every court quotes, but the subsequent portion it is not. According to Santhal law, only males can inherit the land. Sons jointly succeed their father. If brothers co-sharers in a holding and one brother dies without issue, the surviving brother and the sons of predeceased brother inherit his share per sterpies. The Hindu and or Mohammedan law of succession do not apply to Santhals. Santhal tribal law is quite definite in not allowing females to inherit, but this law is gradually undergoing a change, and the situation created by this change is discussed in a separate paragraph below. So here I'll pause. Your Lordship.
आपने मेरा judgment देखा ही नहीं. Have you seen my judgment?
Yes,
I quoted that and have held that she was entitled for inheritance.
yes, I've gone through. We have taken
What's
a printout of that.
Said Hembram का quote. I think Mr. Sharma was arguing that this. है ना? It's Hembram का.
2018 volume 2018 Haradhan Murmu and others versus
2000. दीजिए जरा वो judgment.
That has been taken note by the appellate court also. Para 11
This judgment has been taken.
हाँ है appellate court में वो सब 46 वगैरह court
नहीं 46
only additionally, probably Your Lordship, Lakshmi Bai was an additional fact which would support what is required to be a valid and binding custom so as to disentitle the daughter from inheritance.
So it has to be consistently followed.
Absolutely, absolutely consistent. It has to acquire the force of law. This is what the Honorable Court very clearly. It cannot be at the wishes of a particular person or a wishes of a particular community that they may, in some cases they may give, in some cases they may not give. So here it was not being uniformly followed, absolutely clear from the report itself.
This is way back in 1940.
And that 200 years back, we are already 100 years and we have failed to take note of the subsequent part of the same report.
As a rule, we have tried as far as we could legally do so to record daughters in all cases where not to do so would have involved real hardship. Examples when the main relations are relations not only want to claim the land but refuse to maintain the girl. Where close main relations who obviously have a clear right under the law have been suspected to be likely to desert the girl, we have recorded them, but have also endeavored to record the girl in remark column of the Khatyan as Khosdar under the until death or marriage. Yet this is in connection with unmarried daughters.
para 11 देखा जाए जो appellate court
The rules against
46 or
probably Your
45
Lordship
दोनों
must have
मामले हैं।
already seen this. The rules against the female succession, and Your Lordship must have quoted the rules against female succession among Santhal, whether Christian, non-Christian,
Yes, I
are
have
changed.
quoted it. It is quoted here.
Yes.
That was the basis of passing this
Yes.
judgment.
And then this portion is never quoted. That the law was changing, that time itself it was changing.
And show me from the judgment of the appellate court
Yes.
that
Your Lordship, may kindly
this
see
portion
page-
not only quoted but also considered.
Your Lordship, may kindly see page 11, para 11.
Para 11
Yes.
of the
Of the appellate court. After framing those questions, Your Lordship, para 10, appellate court in para 11 has said, in search of answers noted by question, I find both the consenting parties in the suit admitted and relied upon the customary law in detail by female prescribed at para 14 of the revisional survey report of J.F. Gazetted concerning Santhal district year 1922-25 published in Superintendent Government Printing Press Bihar in 1966. Our Honorable High Court in the case of Narayan Soran and others, Mr. Rajan Murmu and others reported in 2009 JCR has been pleased to discuss such customary law of para 45 and 46 of the Gazetted report which reads in the final report of the revision survey and settlement operation in the district of Santhal Paragana 1932-35, J.F. Gazetted said females. Entry of women name in records. Remove portion of Kanpuri Rule 46 is as follows. If a female is a cultivator of a field, her name should be accompanied by that of her father if she inherited the property from him, or by that of her husband if she inherited him. It may be assumed, therefore, that the revision settlement records have been prepared in accordance with the prescribed rule. But in absence of any definite finding on the point in issue embodied in the dispute list or order passed by the assistant settlement officer, the value to attach to the entries of father's name or husband's name, as the case may be, is open to challenge when the exact nature of women's title is under consideration.
This is quoted from which portion? 45.
45 and 46.
And what about quotation of 37? This is 45.
Para
45
para
है ही नहीं।
para
ये जो कोटेशन है ये कहाँ से पिकअप किया?
कौन?
ये जो इम्प्यून ऑर्डर में है।
वो फर्स्ट है।
2009 का जजमेंट से है, वो जजमेंट जो हमने
अरे जजमेंट से नहीं कोटेशन दिखाई, आप हमको सर्वे से कोटेशन दिखाई। जजमेंट से कोटेशन थोड़ी देखेंगे हम।
कोर्ट ने कहा है, हम दिखाएंगे।
कोर्ट ने कहा बोलने से क्या हुआ? आप हमको ये बताइए कि ये चीज कहाँ रिकॉर्डेड है, ये चीज कहाँ कंसिडर्ड है, ये जजमेंट कब का है?
2009 ये
2012 का जजमेंट। आप हमको बताइए कि वो कहाँ कोटेड है that there is a shift, is it considered? कहाँ लिखा है? बताइए कहाँ है?
According to the authority of law in Santhal Assembly law, male can only inherit the property and the proposition of women in the county of duties or Kano, just like Santhal are people inheritance of the property using the main line in exceptional cases.
I'll show you.
However, Mr. Gangster's report says that there is some gradual change in Santhal custom. Right? In this case in hand, the dispute relates about inheritance of property of recorded tenant Harmu Murmu by descendants of his daughter Joba Murmu on the ground that she was put in Gharjamai marriage with Kanu Murmu of village citizenship. Thus, I confine my discussion only to the extent as to how a Santhal daughter can be put in. Why? Why is it confining it to that? Although there is a specific written statement saying that they are governed, there is a gradual change. They have stated so in the written statement. Why should he confine it to this? In spite of having noted that there is gradual change, he is confining it. Why should he confine it?
Those aspects have been discussed later on.
Let us see what has been discussed. He is confining it. However, I am confining it to this discussion as to whether she got married in Gharjamai form of marriage or not.
Para 46 says that in what circumstances the name of a daughter can be recorded in the settlement, Pacha settlement. Those aspects, that aspect is there. So if suppose at the relevant point of time.
See, the concern is that when the survey way back 100 years back records that there is a shift in custom,
yes.
It means what? It is not being consistently followed.
That what I want to say, that at the relevant point of time, if there was no bar, if there was a shift in the custom or like that, then her husband's name or even her name could have been included in the.
So merely because her name was not included, just a moment, merely because her name was not included, she is excluded.
No. What would be presumption that her husband was never.
You forget about her husband.
Yes.
Forget about her husband.
Rather.
Forget his existence.
Rather the Galu the name. His name was recorded as a Nati Rayat, that is for a temporary period.
Okay, the moment it has become arguable, it has to be framed. As if it is never ending. How could he confine the discussion?
So far as framing of an additional question or substantial question, Your Lordship, it can be framed at any stage if the court is satisfied.
Yes.
I don't disagree to that legal.
I will frame a question whether the appellate court was justified in confining it to this. when there is a specific pleading that they are governed by, there is a change in law.
Question, your lordship, I kindly appreciate. So far as that will also not help these appellates. The reason is the name of the Nati Rayat is already there. And
Whosoever the person may be in the record of right, that will have no bearing.
No, I'm saying, suppose your lordship, the name of the daughter is not there, but his son name is there. So that aspect is there. But question is that whether that was a temporary or it was permanent, or whether the revenants who are the agonists can have any right or not. Those aspects have been considered. So may kindly appreciate it.
You see, entry in record of rights will create title. We are on inheritance.
So far,
and we are on inheritance, and her son have been shown in possession in the record of rights.
our specific case, your lordship,
That is problem.
In the year when we were out, they took possession, and the entry which has been made, your lordship, is an illegal entry, and that is the basis of that is an adopted son. He was an adopted son. That was the basis. That they are themselves not pressing hard. Rather, court has.
We will frame it.
They say that we dispossessed them in 2003. Our name was entered in
Yadas has been proved. Even a competent officer of the settlement.
1966, continuously voter ID of the same village has been. They have their
those
house, they are residing
those
there.
aspects, your lordship, is not helpful to you. He will have to find out a proper question.
According to me, your lordship, the first question, it is actually not a binding custom. Therefore, Lakshmi Bai versus Bhagwan Gua, that test is applied. That custom disinheriting the daughter is not a binding custom.
1987,
Therefore, I am
Patna, your
proposing
lordship, may
the
kindly
first.
have a look on this judgment. 1987 Patna. It is on that point that if by judicial pronouncement, so these aspects, your lordship, has been established. They will not have rights. Now the question, your lordship, is that if there is a shift or something like that, then my lord, your lordship, in Aradhan Murmu, my lord has asked the law commission to to take care of that.
Law commission doesn't.
My lord judgment is there. Your lordship, may kindly.
Law commission doesn't.
So far as Madhu Kiswar judgment, your lordship, Honorable Apex Court has said. But your lordship,
We are not going to establish a custom. But once it is recorded, once a shift is recorded, then we have to acknowledge.
my lord, may kindly appreciate. So far as the tribals are concerned, it is my lord, the Hindu Succession Act itself says that it does not apply.
You just tell us.
It does not apply. So my lord, if they are governed by my lord some.
You see, there are so many judgments we have come across where it is said that this tribal is Hinduized sufficient and therefore it is governed by Hindu customary law, isn't it?
There
So
are
this
judgments
kind
to
of,
that effect.
although you are not arguing on those lines, maybe that in this record it does not come up for consideration. But when there is a change in religion, then it is sufficiently Christianized.
Absolutely. Now,
Then sufficiently Christianized. Although in this case the defendant has said that she is not governed by Christian law, so maybe that this point may not
So far
arise.
as the tribal customary law is concerned, they are governed by their own customs.
No, you just
There
tell
are
us.
several
No,
judgments
there
made.
are several judgments. There are also equivalent number of judgments where they say that this tribal is sufficiently Hinduized and therefore they will be governed by Hindu customary law.
I know that.
So therefore, same analogy. Why will it not lie?
That has to be pleaded and that has to be proved.
No,
Yeah,
and we are just, you see, 10-40 पे 12-40 पे तो discussion ही हो सकता है. But it is not an appropriate case where such an issue is to be framed. Because we have consistent judgments that the tribals having been sufficiently Hinduized are to be governed by Hindu law.
That is
Ek
not the
nahi.
case at hand. That is not the case at hand.
That's right. But we are just discussing.
Yes.
We are not going to frame that issue here because this will not. I will not decide an issue in a case which actually does
My
not.
lord, I would be the
Arise.
happiest person.
आप लेके आइए case.
I would be
हम
happiest
decide
person. But the question, Your Lordship, is there are regards of law
No.
that has to be taken into
अच्छा
account.
थोड़ा 10 मिनट हमको ब्रेक दीजिए. हम आते हैं, but I will frame additional substantial question of law. And Mr. Rahul, you just tell us that this particular observation of the court, that he will confine itself to this, is it not curtailing your
Yes, absolutely. I had marked that, but Your Lordship, how to frame a question with
I will
regard
do
to
that.
this is the only difficulty which I was having.
Please try and do it, and I'll do it.
Yes.
You also try. देखिए ऐसा नहीं करिए. एक important question of law आया है.
Now, so far as this case, Your Lordship, is
वो हुआ था. Law Commission को भेजे थे, इस बार Law Commission को नहीं भेजे.
my friend has not.
This is not required because
यहाँ Law Commission का कोई कहानी नहीं होगा. यहाँ यही कहानी होगा.
These questions does not exist. That I am sure.
No. You see, ये जो observation कर दिया है ना कि इसको हम देखेंगे ही नहीं. I will confine it to whether घर जमाई form का शादी और.
That will not.
and I have not relinquished.
I know.
I have not relinquished.
As if you have relinquished that claim.
Because original judgment was in my favor, their suit had been dismissed. So
Whether
just
Your
not-
Lordship, so far as the SIFT aspect is concerned, SIFT aspect, Your Lordship.
कोई ऐसा केस है जिसमें ह्यूमन राइट इन्वॉल्व नहीं होता है.
नहीं, वो तो
हाँ तो हमारा भी है.